All rise, huye bouleve. The International Criminal Court is now in session. L'audience de Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Yes, good morning, everybody. Could we have the case called, please?
Good morning, Madam President. Good morning, Your Honours. This is the situation in Darfur, Sudan, in the case of the prosecutor versus Ali Muhammad Ali Abd-Al-Rahman. Case reference ICC 0205-120. And for the record, we are in open session.
Yes, we'll start with the appearances for the defence. Mr. Lachi, I don't think we need everybody's bar this morning.
Good morning, Your Honours. Good morning, colleagues. So we have Ali Muhammad Ali Abd-Al-Rahman present today. We've got our interns, Bernard Forest, Claire Chauffard, and Salome Fischer. The legal assistants of the defense are Eva Kelb, Nina Guillou, Ahmed Issa, Anine Hali, Marcela Velarde, and Camille Divet. The legal counsellor, Audrey Mathieu, is also present, my colleague Ian Edwards, and myself, Cyril Lauchi, from the Marseille Bar.
I should never have tempted you, Mr. Lachi. Yes, can we have the prosecution, please?
Morning, Your Honours. Morning to everyone. Same as yesterday, but we are joined by Mr. Santana. Thank you.
Yes, thank you, Mr. Nichols. And finally, the representatives of the victims.
Bonjour Madame la Présidente,
Morning,
Mesdames les juges, chers confrères.
Your Honours, good morning, colleagues.
Sont
The
représentés
victims
aujourd'hui par
are
mon confrère
represented
Alain
by
Chat,
my
mon
colleague
gestionnaire de
Alan
dossier
Shah,
Saïf Cassis et
Saif
moi-même
Cassie's
Nathalie
case
Spinoza
manager,
du barreau
and
de Berlin.
myself, Natalie von Winstinghausen from the Berlin Bar Association.
Okay, everybody, I know it's the last day, but even so. Yes, thank you very much, Ms. von Distinghausen. Yes, Mr. Edwards.
Good morning, Your Honours. After having completed a brief tour of the horizon yesterday relating to the question of credibility, it was by no means comprehensive. I turned to submissions on the three crime scenes of Kurum and Bindis, Mukjar, and Delig, and we'll take those in turn. Can I start with one point, and it's a point that is of relevance to all three of the crime scenes. It is the defense case that Mr. Abd-Al-Rahman was not present at any of these crime scenes at the material time. He's not Ali Kusheb. Whether or not a person called Ali Kusheb was present or not, we do not know. All that we can say is that Mr. Abd-Al-Rahman was not. Senior counsel for the prosecution the day before yesterday regaled us with an anecdote of the four-dog defense, comparing it to our multi-layered defense in his description. Mr. Lauchi will, a bit later on today, address you in detail on the different lines of defense. But suffice it to say that, yes, we unashamedly and vigorously advance the defense that Mr. Abd-Al-Rahman is not Ali Kusheb, and he certainly wasn't known as Ali Kusheb in 2003, 2004. But as we say in our brief, and as we have been saying for a little while now, he has inevitably become associated with the sobriquet Ali Kusheb through no fault of his own and against his will in recent years. That question has always been, remains a hotly contested matter between the OTP and the defence, and it's a matter that Your Honours will have to decide. We know how we hope that Your Honours will rule. We know how we think Your Honours should rule in light of the totality of the evidence. But we, of course, as Mr. Abd-Al-Rahman's defence team, have to make provision for all eventualities. We have to acknowledge that although it would be surprising, Your Honours may find that Abd-Al-Rahman is and was Ali Kusheb, and it would be supremely unwise, Your Honours, if, as a defence team, we placed all our eggs in one basket. I apologise, I've no idea how that's going to be translated into Arabic. So it's the most natural thing in the world, you will understand, to have prepared the ground based on the evidential record for subsidiary, for alternative lines of defence. It doesn't amount in any way to a concession that that a finding by Your Honours that Abd-Al-Rahman and Ali Kusheb is the same person, that would be a correct finding. But whilst we hope for the best, we have to prepare for the worst. And we're confident that Your Honours understand that. We're quite sure that the prosecution understand that as well, notwithstanding the studied bewilderment on the part of the prosecution the other day. And we know that you will not approach our multi-layered defence in a way that is held against us, but most importantly, not held against our client. Any finding that Mr. Abd-Al-Rahman, as Ali Kusheb, was present and criminally responsible for the crimes committed at the three crime scenes would have to be a finding made on the basis of your being satisfied of that beyond reasonable doubt. We say you cannot be satisfied beyond reasonable doubt because the evidence, looked at holistically, does not permit of such a finding. The evidence in respect of each of the crime scenes and in respect of each of the individual charged crimes and in respect of each of the modes of criminal responsibility alleged by the prosecution is simply not strong enough, we say. Now, as far as Kurum and Bindis is concerned, as I hope we've been clear since the outset, the defence do not dispute that the attacks on Kurum and Bindisi actually occurred. The evidence that the attacks occurred is made out, and the evidence that innocent civilians were brutalized, killed, beaten, raped, that homes were burned and pillaged, and that civilians were forced to flee. These crimes, these terrible crimes occurred, innocent people suffered, and the defence for Mr. Ali Muhammad Ali Abd-Al-Rahman do not dispute that. Similarly, we don't dispute that men were arrested and detained at Mukjar and Delig and brutalized and later executed. We accept that. We genuinely sympathize for the victims, the families of the victims, and with the victims' communities more broadly. But our case is actually quite simple. Awful as the crimes were, they cannot be laid at the feet of Mr. Abd-Al-Rahman. He wasn't present. The evidence does not create a link between him and the charged crimes, and that's why he must be acquitted of all 31 counts that he faces. So, what of Kurum and Bindisi? Well, we say that the evidence is riddled, Your Honours, with contradictions, inconsistencies, implausibilities, and indeed evidence from untruthful witnesses. And that these difficulties in the evidence cannot be reconciled in a way that would permit Your Honours to be satisfied beyond reasonable doubt of Mr. Abd-Al-Rahman's guilt in respect of the crimes of Kurum and Bindisi. Your Honours wanted to, one of the questions that Your Honours asked of the prosecution related to documents D and E in question. I'll just bring it up. I'm not going to say anything identifying about the documents, but it's question 6. and documents D and E, the documents that relate to the destroying of Bindisi. Now, the prosecution addressed these letters on Wednesday. We say that the story of how the source of these letters acquired them is frankly ludicrous. If it weren't so serious, the account would be laughable. And Your Honours will, it's so memorable that, of course, Your Honours will recall the circumstances. It's one of the standout features of this case because it's frankly so bizarre. Now, the prosecution have attempted valiantly to persuade you that the source's explanation for how he came to be in possession of these scraps of paper is a good and reasonable one. But we say that the explanations don't begin to survive the slightest scrutiny. If the truth is that the source wanted these documents, surely the most straightforward, the safest, and the quickest way of securing these documents would have simply to have been to take them. I won't say anything about the year, but the source's evidence as to when he saw these documents was several years after the time at issue. These letters were no longer of any relevance because they related to something that was back in history. There's no reason to think that they would have been in any way missed, or at least not right away. Your Honour will recall the way in which the witness said he secreted the documents away. And I ask rhetorically, how is it that he couldn't have done exactly the same thing in respect of the originals? The way in which the documents were secreted away, he says, is, or one can infer, to minimize the chances of them being found, because if they were found, even copies, he would get into a lot of trouble. Well, exactly the same point can be made about the originals. He would have been at no more and no less risk of serious punishment. His explanation for the scrappy version that Your Honours have seen simply makes no sense. The prosecution on Wednesday said, well, bear in mind his background, what he's trained to do. True bill. The documents are fabrications. Now, the reason why I've dwelt on these letters for a moment is because they're the genesis to to Ali Kusheb's involvement in Bindisi, the link between him and the Bindisi operation. If those letters go, that goes a long way to the crumbling of his connection with the Bindisi operation. I'll turn now to the zakat letters. Details of where this letter came from, who wrote it, to whom it was delivered, is not without its inconsistencies. If I talk about the three insider witnesses relating to the Kurum and Bindisi operation, I'm sure you'll know who I mean. But they couldn't get their story straight about the letters. Two said that the letter was signed by Abd-Al-Rahman. Another said it was by Torshain. Anyway, paragraph 389, Your Honour, of the defence brief, we deal with that. There's some confusion about whether it was Hemedan who handed the letter over or Ali Kusheb. a mass of contradictions, of inconsistencies. Why? Because they're not recounting a true story of what happened. There's one quite remarkable inconsistency that's difficult to resolve. It may sound like a small matter. It may sound like it's not that important, but I suggest it is very important. It's this, that Ali Kusheb's alleged mode of transport during the Kurum and Bindis operation, or at least at the very beginning. I want to stay in open session, but there's one of the insider witnesses said that Ali Kusheb joined the convoy some 3 kilometers away from Mukjar on horseback. But that's not what the other witnesses said at all. They said that he was in a vehicle. Now, where would that inconsistency come from? It's difficult to resolve. It's difficult to understand how one could be confused about seeing somebody on horseback on the one hand or in a car on the other. A second insider witness testified that he, Ali Kusheb, Sameh, Shukrullah, and the first insider witness departed the CRF base in Mukjar in 2 vehicles, saying that he didn't actually know Hasabala or the third insider. And the third insider, for his part, says that Ali Kusheb and he departed from Mukjar in only 1 vehicle, with the first insider and 3 guards, Daud Dahab, and a driver. The first and third insiders don't mention the second. It's a mess. It's chaotic. And why is it a mess? Why is it chaotic? Because it's a fabrication. I briefly mentioned yesterday that I'd give you cites to what we have to say about the credibility of the third insider. Time meant I couldn't deal with it in the way I wanted to yesterday, but our brief, paragraphs 363, 388 to 395, and 403. And in short, our position with regard to that witness is that his testimony is worthy of no credit whatsoever. What do we know of the beginning of the operation? Well, we know that the villages of Nieli and Tiro were already in flames before the arrival of the convoy and the insiders, which must place a huge question mark over the issue of which force, or which forces, and more importantly, whose forces were responsible. The trial chamber, we say, cannot exclude the possibility that Nieli and Tiro were attacked by an unrelated group, another group, under someone else's orders. One of the insiders posits that Ali Kusheb spoke to Bonjous and Sameh and was coordinating those early accounts. But our submission is that evidence is simply not as clear as the prosecution would have you believe it is. That insider says he didn't hear what was being spoken about on the phone when he saw Ali Kusheb speaking on a phone. Certainly couldn't understand clearly what was being spoken about. And here I'm looking at transcript 80, pages 49 to 50. And we say that his evidence in that respect is largely speculative. What is clear, however, is that various persons in positions of some authority, Bonjous, a Janjaweed commander, Daud Dahab, Anumda and Mujahideen Emir, Hamouda Hamdan, the Agid al-Ogada in Bendisi, Sameh, another Janjaweed leader, Hasabala, all were present and implicated in the attacks on Kurum and Bindisi. We've lost the live note. Have your honours lost the live note?
In fact, just sent a message to say nothing's happening.
All right.
What's going on? Well, that's great. What does that mean? may have heard that they're working on it. Unspecified time, but a few minutes apparently.
I'm in Your Honour's hands. I'm happy to crack on, but
Well, I mean, I assume they're still taking notes. I mean, I'm still taking notes. They're still recording.
Yeah.
It's just that we can't get it up. Yeah. So I'd carry on, Mr. Edwards.
So, since we dispute that Ali Khrushchev was even present at the scene of the crime crimes in Kurum and Bindis, the crimes would clearly have been committed anyway, but by virtue of the presence of authorities that absolutely could have led the attacks in precisely the way that they were committed. And his presence is not necessary as part of the narrative. The prosecution do not, as we understand it, because they cannot argue that but for the presence of Ali Khrushchev, the crimes in Kurum and Bindis would not have occurred. His presence is therefore entirely superfluous, and that goes a long way to demonstrating, or at least providing indicia, that his presence is a fabrication. He wasn't there. He gave no orders to anyone, and he did not induce anyone. The prosecution make great efforts to highlight broad consistencies, the broad overlap of evidence between their witnesses. And they say that, well, because they broadly say the same thing, our case is based on a solid foundation. Well, superficially attractive perhaps, but we say the devil is in the detail, Your Honour, because that is where you, as triers of fact, will analyse the evidence to a more granular level. That is where the inconsistencies between insider witnesses, in particular, and contradictions in their accounts become ever clearer, and that's where doubts about their reliability become increasingly evident. And realistically, inconsistencies, contradictions can come in all manner of different flavours. That there may be the, as it were, the so what inconsistencies, the who cares contradictions. But that's not what we have here, for the most part. For the most part, the contradictions and the inconsistencies and the implausibilities are of significant importance. And we set those out in some detail in our brief. Now, the prosecution, if we just take a step back, the prosecution are asking you to convict Mr. Abd-Al-Rahman for these most serious of crimes, the most serious crimes known to humanity. If you find that you have no reasonable doubts about the prosecution's case, then, well, yes, of course, you will convict. But we say that the combined weight of the contradictions and the inconsistencies, specifically between these insider witnesses, whose evidence it is that really makes the link between Mr. Abd-Al-Rahman as the alleged Ali Khrushchev and the crimes, as the link between him and the crimes, we are quite confident you will ultimately conclude that the combined weight of those contradictions and the dishonesty and their untruthful denials of their own implication in the crimes of Kurum and Bindis, all of that combined injects more than reasonable doubt into the equation, and that will leave Your Honour and Your Honour's colleagues with no choice but to find that Mr. Abd-Al-Rahman is not guilty. On Wednesday, the prosecution spent a great deal of time frankly just repeating the narrative of Kurum and Bindis and explaining how it unfolded and repeating its case and putting their case at its highest without really grappling with the myriad contradictions and inconsistencies that we identify in the brief and that we continue to rely on. But your honours won't have that luxury. Your honours won't have the luxury of sweeping those problems with the prosecution case under the carpet. You're going to have to deal with it. And we say that having dealt with it, you will arrive at only one conclusion. Final topic I want to address before we move on to Mukjar is what Mr. Jeremy finished on Wednesday. The mens rea of Ali Kusheb with regard to counts 8 and 9, rape, Your Honour's question 20. A great deal of time was spent in the prosecution's submissions and indeed in Mr. Khan's opening on Wednesday about the profoundly negative impact of rape on the Darfuri community. We don't dispute, I reiterate, that rapes occurred and that other forms of sexual and gender-based violence occurred in Kurum and Bindis and indeed elsewhere in Darfur. We don't dispute for a moment that its consequences on the lives of victims and on the community more broadly are enormous, and that tragically the consequences don't just stay with the victim, that it has consequences that are intergenerational. But with great respect, none of that is of relevance to the question of Mr. Abd-Al-Rahman's individual criminal responsibility for rape as alleged in counts 8 and 9 and his responsibility for having ordered and or induced rape. You're going to have to be satisfied beyond reasonable doubt that even if Ali Kusheb did utter the words, Aksa Amsa, cut the straw, eat it raw, and so on, that it was foreseeable that in the ordinary course of events, rape will be committed. Not will, with absolute certainty. I don't put the bar that high. The prosecution in the litigation on the judgment for acquittal, transcript 114, pages 75 and 76, quite rightly said that the absolute certainty test is not the one to be applied because that would be impossible. But the test is will with virtual certainty. And, Your Honour, we urge you to reflect on that standard for a second or two, because it is a high bar. It is a higher bar than the test that the prosecution advance in their brief at paragraph 383 of Wood. The prosecution's argument that he was aware that rape would be committed in the ordinary course of events, should be will, but there it is based on the vaguest of generic factors that are simply not supported by the evidence, we say. Astonishingly, one of the witnesses that the prosecution rely on is P547. I would urge you, we would urge you to go back to the transcript of 547's evidence. It's a transcript 52 from page 81. He was answering questions from Her Honour Judge Alapini Gansu in general, not specific terms, that killing, rape, looting generally took place in the field. And Ali Kusheb, as a Forsan commander, like the others, would have a responsibility for that, would be aware of that. But the witness had no specific knowledge of Ali Kusheb at all. he did not know, he could not have known what was in Ali Khrushchev's mind in 2003 and 2004 in general, and certainly not on the 15th or 16th of August of 2003. They didn't know each other. They'd never met. Paragraph 385 of the prosecution brief, they make reference to rape being a consistent feature of government of Sudan counterinsurgency campaigns, and that Mr. Ali Muhammad Ali Abd-Al-Rahman had taken part in such counterinsurgency campaigns in the south of Sudan in the past. Well, that's grasping at straws, we say. That the prosecution has provided no evidence that rape specifically occurred systematically or at all in the context of the activities of Mr. Abd-Al-Rahman during his deployments in South Sudan. And frankly, they ignore the fact that for the vast majority of his time in the army, he was a nurse, a medical assistant, not a combat soldier. So one understands why they try to make the link, but they're grasping. Paragraph 386, the prosecution rely on the fact that rape occurred in villages attacked prior to Bindisi. But we say, where is the proof that permits you to find beyond a reasonable doubt that he did know about rape occurring in villages attacked prior to Bindisi? We say that that is purely speculative. There is nothing in paragraphs 387 to 391 to prove beyond reasonable doubt that he knew that rapes will be committed in the ordinary course of events. And I refer to our submissions made in paragraphs 431 to 439 because they set out the factors that Your Honours have to take into account in terms of what fixes him with the requisite knowledge. Haroon's speech, what was said on the night of the 15th of August, and so on. And we set out the factors that inject significant doubt. One final point is the context of how you should find the terms Aqsa Amsa and how those would be used and understood. And with great respect, it's deeply unhelpful for the prosecution to rely to refer to and rely to jurisprudence from the Taganda trial judgment in support of their position. What words were used in the context of a different armed conflict at a different time in a different country involving different actors doesn't help, Your Honours. The way in which Aqsa Amsa and Cut the Straw and all the rest of it would have been used and understood in the context of Sudan, in the context of Darfur in 2003, 2004, in the context of Arabic as opposed to Swahili. That's what you have to look to. It is a supremely fact-specific exercise. And looking at case law, it's a misuse of case law, I would submit. It's certainly hopeless. The legal approach, however, not the fact-specific, but the legal approach that we submit is relevant and of use. In your assessment of words of alleged encouragement and inducement is set out clearly and rather neatly in the ICTR Perlich first instance judgment of the 29th of May 2013. This is where...
ICTY, I think.
Did I say ICTR? Forgive me.
Yes.
ICTY, yes, obviously. And in that case... sorry, one moment. I'm not too sure if I can find it, but I think it's the late Pryliak who was said to have used the words relating to the situation in Varesh to show no mercy to anyone. And the trial chamber in that case, not looking at anything particularly fact specific, but they set out the approach that is useful in law. Paragraph 642. Time is not on my side. I'm going to move on now to Mukjar with your leave. Paragraphs 155 to 202 in our brief. Again, our case is that Abd-Al-Rahman, as Ali Kusheb, allegedly, was not present at Mukjar police station at the material time or at any execution site. You would have to be satisfied beyond reasonable doubt to the contrary. And we say that you cannot be so satisfied because the evidence is, once again, even looked at holistically, it is simply not strong enough. We submit that the prosecution has failed to establish with sufficiently reliable and credible evidence the existence of a so-called Mukjar common plan. That's explored by the OTP in their brief from paragraph 477. We say there's not enough there, and there's certainly not enough to establish Ali Kusheb's contribution to that plan. For what it's worth, the case law relied on by the prosecution in terms of a common plan and how to look at questions of co-perpetration is accurately set out, both in terms of and that applies both to Mukjar and to Delig. The case law in this court's Kilolo case, the decisive consideration for determining whether an accused person must be qualified as a co-perpetrator is whether the individual contribution of the accused within the framework of the agreement was such that without it, the crime could not have been committed or would have been committed in a significantly different way. And that's from Kilolo, that's from the Kilolo case, Appeals Chamber, 8th of March 2018 at paragraph 820. And that more recent case law mirrors the very early case law from Lubanga. The contribution of the co-perpetrator must be essential. Paragraph 999 of the first instance Lubanga decision. With the involvement of the PDF in Mukjar through Hasabala, the involvement of military intelligence through Hamdi and other SAF, senior SAF members, the OTP has failed to prove beyond reasonable doubt that Ali Kusheb made a contribution that was essential and that without his contribution to the crime, the crimes would not have been committed or would have been committed in a significantly different way. It applies both to Mukjar and to Delig. These crimes were undeniably dreadful, but they cannot be connected to Mr. Abd-Al-Rahman. I'm just going to focus on one or two matters that are particularly troubling in our submission. At paragraph 492 of their brief, Ali Kusheb is said to have personally arrested Abakar Abdelmullah and to have driven him to Mukjar police station. He would have been executed a few days later. Now, we address this in paragraph 478 of our brief, but I nevertheless think that it's worthwhile running through some of the facts here and the frailties of the prosecution evidence. The source of this information is 720. We say that he had no reasonable basis for identifying the man he refers to as Ali Kusheb, other than through hearsay evidence from Abdul Mullah. but there's no information as to Abdul Mullah's own basis for knowing that the person that arrested him was Ali Kusheb. 720's own knowledge, the basis of his knowledge of the execution, is also based on hearsay. He says that Abdul Mullah, and Your Honour, it's in fact Annex 17 of the OTP brief. It may be worth bringing up now, but at Annex 17 of the OTP brief, we see that Abdul Mullah is victim number 1. And you see that the footnote 1, we see that the source for the information regarding his death is twofold. P720, as I say, but also P129. Sticking for a moment with 720, well, his evidence, or the basis of his knowledge of Abdul Mullah's execution, is based on hearsay. He didn't see the loading of prisoners into any vehicle. He says that he and other people had seen vehicles carrying prisoners leaving in the direction of Garcilla, but he didn't see Abdul Mullah in any of the vehicles, certainly not executed, and he didn't see his body after the execution. Excuse me. But in terms of what we know about Abdul Mullah coming from 720 and P129, there's a significant and very troubling contradiction. Because P129, the other source, I pause for a moment because I say for reasons that I went into yesterday, we say that 129 is a highly unreliable witness for various reasons. He's a witness who talks quite a lot about children being imprisoned at Mukjar. But his evidence about that fluctuates over time, and the number of children that were imprisoned in Mukjar fluctuates over time. In his first account, well, I won't give the year, but it's in his first account, it's DAR OTP 0128 at paragraph 48. He talks about seeing one boy of 12 to 13 years old, and then seeing him again during a second period of detention, but he doesn't know his name. What he does say is that he believes he was subsequently released, but he doesn't know when. Now that evolves so that by 2021, one boy turns into 3 boys. And one of those boys, he says, was hit in the head by Ali Kusheb when Ali Kusheb was hitting an umda. He doesn't give a name, there's no suggestion that it was necessarily deliberate, sort of transferred malice sort of situation, but he provides no name for the 3 boys. And that's at DAR OTP 02200703 at paragraph 58. And then, in DAR OTP 0000086, this turns into 7 children, 7 people under the age of 18. And I don't ask that we won't be able to bring it up, but when you look at 0000086, that's his list. The person that he describes as Abakar Abdul Mawla is between the ages of 11 and 12. So we come back to Annex 17, Abdul Mawla, the 4 victim mentioned by P720, the other source, Well, he's a man who was between 30 and 35 years old, a student farmer from Mukjar, the son of a cattle owner. They're clearly not talking about the same person, although the prosecution conflates this evidence about one Abakar Abdul-Mullah. There's either a mistake, but we say most likely P129 is simply completely wrong. He's either making it up, because that would be consistent with what we see in his evidence about the evolution of his account of seeing children detained and killed. And we say that this is further evidence of P129 making things up, embellishing his account, and fabricating a case against Mr. Abd-Al-Rahman for reasons of his own. We say that this worrying aspect of P129's evidence goes some significant way into throwing his evidence about who he purports to identify, his evidence of who had been arrested and imprisoned at Mukjar, the reliability of his evidence throws it into doubt. We were criticized on Wednesday by the prosecution for seeking to take advantage of a moment of confusion that that witness had, P129, that he experienced with regard to timing of a public speech. And this is at real-time transcript from Wednesday, page 109. And it was said that, of course, we shouldn't be allowed to capitalize on confusion when a witness is reliving traumatic events in the past whilst giving evidence. Now, whether or not it's fair to capitalize on inconsistencies and contradictions when seeking to establish a challenge to credibility, whether that's right or not, what we do submit is that it's a wholly valid point simply to point out to the court that where frailty in a witness's memory associated with trauma is present, that may impact on a witness's reliability of their memory. That must be a fair thing for the defense to explore and to point out. This is evidence that dates back very many years, of course. The detainees at Mukjar underwent the most traumatic of events, of course. Confusing, terrifying, and your honours will know from experience that memories created in times of stress and trauma can present significant reliability challenges. We ask you to take that into account in your assessment of the reliability of the evidence of the detainees, including the accuracy of victims' lists from Mukjar. The same point can be made in respect of Delig. One final thing before I move on to Delig. I just want to briefly touch on the prosecution's case regarding execution sites and a fundamental problem that we say exists with their approach to the order in which executions took place and the number of execution sites. Here we have, from two witnesses, two accounts that cannot be successfully understood, looked at together. In their submissions on Wednesday about execution sites, the prosecution refers to the first execution site near the sycamore trees. That's fine. The next site is referred to at paragraph 454 of their brief. I want to stay in public session, so I won't identify the witness, but this is the evidence of the killing of the sheikh and 7 children. That comes from a single witness, and that's a witness whose credibility is very much in issue. His evidence is uncorroborated. A survivor witness identified in the title above paragraph 456 in the OTP's brief says that the convoy moved on from the second execution site to the third and final execution site. But that survivor witness says nothing about the execution of the sheikhs and the children. He says, and the witness of the execution of the sheikh and the children says nothing about the supposed third execution site. But they're driving in the same convoy. There's no evidence that one part of the convoy at any point peels off. See, for example, transcript 88, page 73. And we say that there's no explanation that stands up to any scrutiny that the survivor witness would not have observed the killing of the sheikh and the children. Yeah. And the survivor witness is a witness who, Your Honours will remember, provided a great deal of evidence. He had a remarkable ability on the face of it to remember details such as the precise words spoken by Ali Kusheb in the convoy. He gave a great deal of evidence that the prosecution asked you to accept, and yet it's just irreconcilable, we say, with his failure to give evidence of the murder of the sheikh and the children. And the conclusion, the consequence of that, we say, is that the killing of the sheikh and the 7 children simply didn't happen. The OTP can't reconcile these difficulties, and they make no persuasive attempt to do so. I've only got 10 minutes left, so I'm going to move on now, I think, to... I was just going to say that in our brief, we refer to the authorities that were in Mukjar. Al-Jili, the commander of the police in Garcilla, Al-Taib, the head of the CRF and the head of the Mukjar police station, that these were authorities that were in a position to give orders to carry out the crimes, and their presence, their authority makes it less, not more likely, that Ali Kusheb had no role to play and that he's not guilty under co-perpetration for the reasons set out in what we say about Kilolo, in the cases of Kilolo and Lubanga. Right, very briefly, Delig. Full submission set out in our paragraphs 560 to 663, and I'm not going to repeat those here. Suffice it to say, our case is that the prosecution's case with regard to Delig is replete with contradictions and inconsistencies. Beyond the most superficial assessment of the story, once Your Honours scratch below the surface, you'll see that the OTP has failed to present a clear and convincing narrative of what transpired in Delig. Specifically, we say, a reliable narrative in terms of the role played by Ali Kusheb. You've been given, really, an incoherent and fragmented patchwork of information about dates, about time frames, about perpetrators, about sequences of events. And it's inadequate if you're going to be asked to conduct a full and fair assessment of the evidence, and if you're being invited by the prosecution to find Ali Kusheb's doubt beyond reasonable doubt. And our client, Mr. Abd-Al-Rahman, must benefit from from that doubt. Very briefly, there's one point in the time that I have left that is worth raising for Your Honour's consideration. Paragraph 397 of the prosecution's brief makes reference to the fact that the Sindhu convoy, consisting of Abd-Al-Rahman, should be Ali Kusheb's vehicles, 700 to 800 militia. Putting it in the most neutral and understated way, of course, it's an issue in this case between the prosecution and the defense that Abd-Al-Rahman was a Janjaweed leader. But it's a remarkable fact of this case that despite calling a number of insider witnesses to try and establish Mr. Abd-Al-Rahman's leadership within the Janjaweed, including a number of witnesses who accept no liability for their own actions, even though their responsibility, their criminal responsibility is absolutely clear. It's remarkable that the OTP has not called a single militiaman. There has not been a single Janjaweed accomplice witness. And you'll know that at the ICTY and the ICTR, these were often the most significant, the most important witnesses. The Inter Hamwe, the Bosnian Serb soldier, for example. There isn't a single Janjaweed called by the prosecution to testify to say, I saw Ali Kusheb, I heard Ali Kusheb, he was my leader, he was the one who ordered me and my brother Janjaweed to commit crimes, and we obeyed, and we knew what Aqsa Amsa meant, and we knew what cut the straw and eat it raw meant, and we heard it and we understood it. There is no reliable evidence of the so-called Delig common plan, and the Kilolo and Lubanga tests applied just as much to Delig as they did to Mukjar. Hamdi, he was involved, he was there, he was senior, he was arguably in a position of seniority as compared to Ali Kusheb. Through P994 and P883, it said that Hamdi wasn't present at Delig police station. 643, however, says he was, that the police station was managed by Hamdi after he took the keys from Juba Hassan Fadali, the chief of the Delig police station. And thereafter, Hamdi was the boss, the manager. It was Hamdi, with Ali Kusheb, who removed the detainees from the jail, had them lie face down in the open area in front of the police station before having them driven away to be executed. The prosecution cannot say that Ali Kusheb played such an important role that but for his presence, but for his orders, the crimes wouldn't have been committed. The search and arrest operations. Well, the prosecution said on Wednesday, page 134 of the transcript, that Abd-Al-Rahman participated in search and arrest operations, that he was present and gave orders for the arrest of a particular Umda, relying on uncorroborated evidence from 955, uncorroborated and indeed contradicted by prosecution witness 883. I'm going to finish by talking about murders briefly in the time I have left. I have 4 minutes left. This is important. It's a shame that I'm having to deal with this at the end, but there it is, chronologically, there we are. In their brief, and on Wednesday, the prosecution accused Ali Kusheb, Mr. Abd-Al-Rahman as Ali Kusheb, of directly murdering two men, Jenef, the man by the nickname, Adam, the man who has the nickname Jenef, and Adam, the same name as Jenef, but with the nickname Mota. We say that even if there is evidence that Ali Kusheb, taking the prosecution's case at its highest, even if there's evidence that he did strike both Jenef and Mota with an axe or a stick to the head, the evidence is insufficient to establish beyond reasonable doubt that these blows killed those two men. And in fact, the prosecution appears to concede as much at paragraph 548, that it's possible that they weren't killed at that time because they advance an alternative scenario in which they say it's reasonable to infer that they died after being transported to an execution site, either due to the absence of medical treatment for their injuries or because they were then shot. But there is not even firm evidence, we suggest, that the injuries to the heads of Genève and Mota went beyond what might be called actual bodily harm and crossed into the into the realm of serious bodily harm. There's evidence maybe that Genève lost consciousness, but I think I'm right in saying that there's evidence that he may have been on his feet some time later. There's no evidence that one or both didn't die by dint of an intervening event. They may have that if they died, they were shot by another person in authority, or another Janjaweed militiaman, or indeed killed at the execution site or an execution site under the orders of someone else. We simply don't know because there's no evidence. And we refer to our defence briefs at paragraphs 593 to 595. Quite apart from the fact that there are three witnesses who mention the striking of Genève by Ali Koucheb in three different ways at three different places at Delig police station, and another witness who says that Genève was actually killed at the execution site with the Umdas, that's P883. And as far as the murder of Mota is concerned, well, P907 is the only witness who mentions both murders. I won't say them because there are two witnesses who do not mention the murder of Sheikh Mota, and one other witness who does not mention the murder of Genève. There are four witnesses who were at Delig police station who don't mention either murder. Do I have time? Very briefly, last point, the executions. On Wednesday, the prosecution firmly and clearly set out their position. Regarding the evidence on the transport of detainees to the execution sites, our case is, and has always been, that there were several transports to multiple sites. But that evidence is simply flatly contradicted by the evidence of one of their star witnesses. If I describe him as the sees everything, been everywhere, hears everything witness, that evidence is that there was a single convoy, a single transport, one single occasion of 13 vehicles to a single site in Delig. And the prosecution don't explain why it is that, in terms of this witness, their choice is to ignore it. Your Honor, I was going to address persecution. That was addressed by Madame Matteo yesterday. I know that I'm going to get into a lot of trouble if I don't sit down now. Thank you for listening.
Thank you, Mr. Edwards. Mr. Lauchi.
À l'attention des interprètes.
Just for the interpreters, I'm going to read my notes,
Les rares fois où
and
je m'en écarte,
when
je
I
ralentirai.
will digress, I shall slow down.
Mon exposé de ce matin
The
est en
subject of my
relation
presentation this
avec
morning
Regrettably, Mr. Lauchi, the fact that the interpreters have your notes does not mean they can read them out at the speed at which you are already starting to talk. They've still got to read them out So you need, I appreciate you're worried about time, but
Extremely.
yeah. But don't forget, you said a lot in your final brief. And really what this is for is to amplify rather than to repeat. And as I say, don't worry about our questions because we'll deal with them separately. But you must slow down. They can't keep up.
Thank you, Madam President. Je commence par
So
la
I will
ligne
start
1.
with line 1.
Monsieur
Mr. Abd-Al-Rahman
n'est pas
is not
Ali
Ali Kushaib.
Les mémoires du bureau
The
du
briefs of
procureur
the
et des
OTP
représentants légaux des
and the
victimes
LRV
s'appuient
rely successively
successivement
in
dans leur
their
démonstration
demonstration
sur
on
diverses
various categories of evidence.
Certaines ont été répondues
Some
dans le mémoire.
of them
Je n'y reviens pas.
were
Je m'adresse
already
exclusivement
addressed. I
aux
won't
autres.
come back to it, and I'll just concentrate on the
La première
others.
catégorie
The
est
first
la preuve
category is
testimoniale.
the testimonial evidence.
Dans sa démonstration que M. Abd-Al-Rahman ferait Ali
Abd-Al-Rahman
Kushaib,
would be
le
Ali
bureau
Kushaib.
du
The
procureur
OTP
s'appuie sur
relied successively
témoins.
on 4 witnesses.
P643,
P0643,
P874,
P0874, P0883, and
les
P0905.
représentants légaux des
The
victimes
LRVs
reprennent les mêmes.
rely
Et
on
y
the same
ajoutent 10
evidence
autres.
and add 10 others.
Nous avons discuté la
So
crédibilité
we talked
des
about
4
the
témoins que j'ai
credibility
cités.
of the
Je n'y
4
reviens
witnesses.
pas.
I'm not going to talk about it
Le seul
again.
témoin sur lequel
And the
rien n'a
only
été dit
witness
jusqu'à
about whom
présent
nothing has been
est le
said
témoin
is witness
P916
P0916 mentioned
note de bas de
in
page
footnote
205
205
des représentants légaux des
of
victimes.
the LRV.
en parler.
I will deal with him.
Avant ça,
But before I do that,
je commencerai par
I
réfuter
will begin
la
by
suggestion
rebutting the
formulée au
suggestion
paragraphe 8
in paragraph
du
8
mémoire du bureau du
of
procureur,
the OTP's brief
selon laquelle la
that the
défense ne
defense
serait
would
plus en
no
position
longer be in a position
contester
to
que
dispute
M. Abd-Al-Rahman
that Mr.
porte
Abd-Al-Rahman
le surnom
goes
Ali
by the
Kushaib
nickname Ali
parce
Kushaib
qu'elle n'aurait
because
pas
it
soumis au
did
témoin
not
qui le
submit to the
prétendait
witness who
que
alleged
son surnom
that his
était en
nickname
réalité
was
Abu
in
Nasser.
fact Abu Nasser.
Il est bon que
It
le
is good
procureur
that
se
the
souvienne de cette règle,
OTP admits
prétendre l'ignorer.
this, and hence they
mais cette
cannot
règle est sans
pretend to ignore it.
pertinence pour ce que
But the
le bureau du
rule is
procureur essaie
irrelevant to what
d'établir.
the OTP is trying to
Le
establish.
surnom Abu
The
Nasser
nickname Abu Nasser
question
is a
distincte,
separate issue
sans rapport
and
avec
is not
l'alias
related
Ali
to the
Kushaib.
alias
La
Ali
défense
Kushaib.
a
The defense
systématiquement
systematically
confirmé,
challenged the
contesté
witnesses,
l'affirmation
challenged the witnesses'
des témoins
assertion
selon lequel
that
Ali
Ali
Kushaib
Kushaib
serait M.
was
Abd-Al-Rahman,
Mr. Abd-Al-Rahman.
et elle leur a
It
fait
made
savoir
them
dans les
aware
termes
of
les plus
this
clairs
and
afin qu'ils
gave them
puissent justifier
the opportunity
sur cette
to
question.
justify their evidence on this
La
issue.
défense a donc
So the
scrupuleusement
defense
respecté
scrupulously
la règle fixée
complied
par la
with the
Chambre
rule laid down by
et
the
continue
chamber
d'être
and
fondée
therefore
à contester
continues
l'alias Ali Kushaib.
to challenge the alias
En ce qui
Ali
concerne le témoin
Kushaib.
P916,
With regard to witness
il a précisé ne pas
P0916,
connaître
he
personnellement
stated that
Ali
he
Kushaib,
does not know Ali
mais avoir
Kushaib
entendu parler de
personally,
lui
but
dans la
had
rue
heard
sans plus de
mentioned
précision.
in the
C'est,
streets without providing any
le
further
document
details. It's
64
document,
dans la table des
it's
autorités.
item 64 in the table of
Le témoin
references.
P916 ne fait donc
Witness
que rapporter un oui-dire
P0916 was therefore
anonyme,
merely reporting
non
an
daté,
anonymous and
comme
undated
base de sa
hearsay on
connaissance
the
d'Ali Kushaib.
basis, as the basis of his
valeur
knowledge of Ali
Le bureau du
Kushaib.
procureur,
No
d'ailleurs,
probative value
ne
can be
s'y
attached to
est pas
this.
trompé,
The OTP
ne s'y réfère même pas.
does not even refer to it, was not
Enfin, les
mistaken.
représentants légaux des
Finally, the
victimes s'appuient
LRV
sur le
rely
contre-interrogatoire
on
du
the
témoin
cross-examination
D32,
of witness
dans lequel
D32,
il
in which he
mentionne avoir
mentions
entendu
having
parler
heard
pour la
about
première fois
Ali Kushaib for
d'Ali
the
Kushaib
first time
en 2003,
in
2004, à Garcia,
2003-2004 in
et
Garcilla,
tout le temps depuis.
and all the time since.
Il n'aura pas échappé à la
It will
Chambre
not
que
have
le
escaped the
témoin
court's
D32
attention
présentait
that
des
witness
capacités de compréhension
D32 had
limitées
limited comprehension skills
et a été
and
plus que
was
confus
more than
tout au long de son témoignage.
confused throughout his testimony.
Ainsi, vous référez au passage
You
du
can
document
refer
84 dans
to
notre liste,
item 84
le
in
témoin
the
D32 a
list.
prétendu
The
avoir entendu parler du
initially
mandat d'arrêt
claimed to
à
have
l'encontre
heard
d'Ali
about the arrest
Kushaib
warrant
en
for Ali
2001
Kushaib in
ou 2002,
2001 or 2002,
quand la Cour
at a time
n'existait
when the
même
court
pas.
did not even exist.
pour finalement conclure
before
qu'il ne
finally
se souvenait
concluding
pas
that he could not remember when
il avait entendu
he
parler
had heard about it
de ce mandat d'arrêt
and
et
about
de
the
dire
arrest
qu'il
warrant, and
il en avait
he
entendu
had heard
qu'il en
what
avait
was
entendu parler
said
dans les médias.
in the media.
Médias qui ne
The
faisaient
media
que
which was
diffuser
just
les informations en provenance de la
disseminating the court's information.
La seule conclusion
The
raisonnable
only
que
reasonable conclusion to be
pourra
drawn
tirer
from
du
his
témoin D32
appearance
est qu'il ne
is
se souvient
that he
pas
does not remember
de quand
when
il a
he
entendu
first
parler d'Ali
heard
Kouchaïb
about
pour la
Ali
première fois.
Kouchaïb.
Mais ce qu'il y a de commun entre
What
P916 et tous les autres
P0916
témoins
has in common with almost all the other witnesses,
et la
in
quasi-totalité des
fact,
témoins sur lesquels le bureau du
with
procureur et
almost
les
all the
représentants
witnesses on
légaux
whom
des
the
victimes
OTP and the
s'appuient
LRV
dans leur
rely
mémoire,
in their brief
et le fait qu'ils ont été
is the
interviewés
fact that
par
they
le
were
bureau du
interviewed by
procureur
the OTP
après
after
le 27 février
27
2007.
February 2007.
C'est-à-dire
That is,
après
after
que le bureau du
the
procureur
OTP
a rendu
had made
public
public
et largement
and
diffusé
widely disseminated the
les
information
informations suivantes. Première information,
that
Ali Kouchaïb
Ali Kouchaïb
se nommerait en réalité Ali
was in
Mohamed Ali
fact
Abd-Al-Rahman.
Ali Mohammed Ali Abd-Al-Rahman.
Deuxième information,
Second piece of information,
Ali Kouchaïb
Ali
aurait
Kouchaïb
porté le titre de
would
Agid
have held the
al-Ogada,
title of Agid
pièce numéro
el-Ogada,
1, paragraphe
item 1,
36.
paragraph 36.
Ali Kouchaïb
Ali Kouchaïb
serait âgé
was
d'environ 50 ans en
approximately 50
2007,
years old in 2007.
c'est la même pièce, paragraphe 37.
Same item, paragraph
Ali
37.
Kouchaïb serait de
Ali
la tribu
Kouchaïb
Taïcha.
would have been from the Taisha
Même
tribe, same paragraph.
Ali Kouchaïb
Ali
tiendrait
Kouchaïb
une pharmacie vétérinaire
ran
à
a
Garcilla.
veterinary pharmacy
C'est
in
le
Garcilla,
paragraphe
It's
203.
paragraph 203.
Ali Kouchaïb aurait
Ali
été employé en
Kouchaïb was
2007
employed
comme
in
assistant de
2007
police
as a
au
police
Darfour
assistant
Ouest.
in West
C'est
Darfour.
l'annexe 12
That's
du
Annex
document 1
12
au
of
paragraphe 4.
document 1 of paragraph 4.
Ali Kouchaïb
Ali
aurait
Kouchaïb
été arrêté le
was
26 novembre
reportedly arrested on
2006,
26th of
paragraphe.
November 2006, same
Et
paragraph,
Ali Kouchaïb
and Ali
serait encore
Kouchaïb
en
was
détention
still
en
in
février
detention in
2007.
February 2007.
C'est le paragraphe
That's
276 du document 1.
76 of document 1.
Comme vous pouvez le constater,
As you can see,
nul n'est besoin
you don't need
d'une
a
conspiration
conspiracy
pour
to
fabriquer la
create the
légende Ali
Ali
Kouchaïb.
Kouchaïb legend.
Seul le bureau du
Only
procureur et
the
les représentants
OTP
des
and the
victimes d'ailleurs
LRV
utilisent
use
ce mot
this word,
et la
which
défense
the
quant
defense
à elle n'a jamais
has
utilisé
never
le mot
used
conspiration et le réfute.
the word conspiracy and
De même,
refutes
hier, la
it.
distinguée
Similarly,
représentant légale
yesterday,
des
the
victimes
distinguished
a suggéré que la défense
representative
ferait un
victim suggested
parallèle
that the defense
avec
was
un
drawing a
précédent
parallel with
devant
a
le tribunal pénal
precedent
international
before
pour le Rwanda.
the ICTR.
J'ignore
I
à quoi
don't
mes
know
collègues
what my colleague
se réfèrent.
was referring
Je
to,
réfute cette
and I refute
interprétation.
this interpretation.
Je n'ai jamais entendu parler
I've never
de
heard
fabrication collective de
of
mémoire dans le cadre
conspiracy,
du
collective
tribunal pénal international
conspiracy
pour le Rwanda. Et
in the
je pense qu'il ne fait
ICTR,
pas-
and
il ne fait aucun doute
I don't think there's any
possible
doubt
que le génocide
that
rwandais
the
a bien eu lieu.
Rwandan genocide
Nul
did
n'est
take
besoin d'une
place.
conspiration,
There is
d'une
no need for a
conspiration,
conspiracy,
Nul n'est besoin
So-
d'un soi-disant précédent rwandais dans notre
no
affaire.
need for a so-called
L'action
Rwandan precedent in our case.
bureau du
The action of the
procureur suffit.
OTP
Relayé par les médias,
relayed
a
by
créé
the
la
media
légende
was enough
Ali
to
Kouchaïb
create the Al
et
Kouchaïb
à lui
legend
donner corps
and
avec
to
les
give it
9 informations.
substance with 9
je viens
pieces of
d'énumérer.
information that I just mentioned.
Cela signifie
Now,
que,
this means
en disant à la
that
Cour
by telling the
que Ali
court that
Kouchaïb
Ali
est
Kouchaïb
Monsieur
is
Abd-Al-Rahman,
Mr. Abd-Al-Rahman,
et en se référant
and
à l'une ou
by
l'autre de ces
referring
9
to one
informations,
of these 9 pieces of
la
information,
totalité des témoins,
all
sans
of these
exception,
witnesses, without
rien
exception,
d'autre
are doing nothing more
que répéter
than
l'information
repeating
rendue
the
publique par la
information
Cour
that was made
et
public by the
largement
court
diffusée
and
par les médias,
widely
en
disseminated by the
particulier les
media,
médias soudanais.
especially the
Disent-ils la
Sudanese
vérité?
media. Are they telling the truth?
Ou ne font-ils
Or are
qu'adapter leur
they
témoignage
just
à la cause du bureau
adapting
du
their
procureur?
testimony to the cause of the OTP?
Vous ne disposez pas, mesdames les juges, vous ne disposez
Your
d'aucun
Honours,
moyen
you
fiable
have no
de le déterminer.
reliable way of determining
Le
this.
bureau du procureur,
The OTP
par les informations qu'il a inutilement rendues publiques le
Has-
27 février 2007,
undermined
a
the
sapé
reliability
la
of its
fiabilité
own
de sa
evidence by
propre
the
preuve.
information it
Quand
unnecessarily
bien
made
même vous
public
seriez encline
on the 27th
à
of February
considérer qu'un témoin
2007.
semblait
Even
crédible,
if you were inclined to assess the
un doute
performance of
raisonnable
any of
subsistera.
the witnesses on
Il n'est en
whom the
réalité fait
OTP and the
que
LRV
répéter
rely in their
les
brief,
informations
there
qui
still
étaient
will
diffusées dans les médias
there will still remain a reasonable
et qui
doubt that
prouvaient
they
leur
have in
origine dans
fact
l'action
merely
du
repeated
bureau du
information
procureur.
disseminated by the media by the action of the OTP.
Avec ce précédent, la preuve
Now,
testimoniale
with this precedent, the
d'aucun secours
testimonial evidence on
et
the
devra être
case, on the OTP and the LRV
Le deuxième
line
élément de
briefs and
démonstration
must be
sont
discarded.
les divers éléments
The
de
second
biographie
element is the
réels
various
ou allégués
elements of
qu'il aurait en commun avec, que M.
the-
Abd-Al-Rahman aurait en commun.
Mr. Abd-Al-Rahman's
avec Ali
actual
Kushayb.
or alleged biography.
Le bureau du procureur
The
s'y réfère pour dire qu'il
OTP
s'agit
refers
en
to
réalité d'une
various
seule et même
biographical
personne.
elements, and he claims that they
Alors,
are the one
comme
and
je viens
same
de l'indiquer,
person, as I just
les
indicated,
informations selon
information
lesquelles
according to
M.
which
Abd-Al-Rahman
Mr.
et Ali
Abd-Al-Rahman and Ali Kushayb
serait Taïcha,
were Taisha,
aurait porté le titre
had the
Agid
title of
al-Ogada
Agid
et
al-Ogada,
aurait tenu une
and
pharmacie
had
sur le
run a
marché de
pharmacy
Garcilla,
in the Garcilla
qui est
market,
d'ailleurs situé
which
à
is
proximité
near
de la
the
Banque agricole,
agricultural bank,
était largement
was
connu,
widely
diffusé dans le domaine
circulated
public
in the
à
public
partir
domain
du
from
27
27th of February
2007.
2007.
La Chambre
The
ne peut
Chamber
pas s'y fier raisonnablement.
cannot reasonably rely on this evidence of
Une
the
fois que
identity.
l'information,
Once the
l'information que M.
information that Mr.
Abd-Al-Rahman
Abd-Al-Rahman
ou
or Ali
Ali Kushayb sont de la
Kushayb
tribu
are
Taïcha,
from the Taisha tribe
diffusée au public,
that has been publicly
l'information
disseminated,
selon laquelle
the
les deux
information that they
seraient
both
originaires
come
de
from
Raed
Raed el-Bardi
ne constitue rien
is
d'autre
nothing more
que la
than
conséquence naturelle de
just
cette
a
information.
natural consequence of this
Raed
information. Raed
et sa
el-Bardi and
région
its
sont le Dar,
region
le
are the
territoire
Dar,
d'implantation
the settlement
de la tribu
territory
Taïcha.
of the Taisha tribe.
Cette information n'a donc
This information
aucune valeur
therefore has
probante.
no evidentiary
La
value.
preuve sur laquelle le
The
bureau du
evidence
procureur
on which the
s'appuie
OTP
en note de
relies
bas de page
in
170
footnote 170
ne dit pas
does
d'ailleurs
not
qu'Ali
say
Kushayb
that
était
Ali
Taïcha.
Kushayb is Taisha.
Le témoin
Witness
P12
P12
prétend
claims
Kushayb
that
serait
Ali
Rizigat.
Kushayb is
Le
Rizigat.
témoin
Witness
P119 dit qu'Ali Kushayb
P0119 says
serait
that Ali
d'une tribu
Kushayb is
non-arabe.
from a
Et
non-Arab
le
tribe,
témoin
and
P932
witness P932
sur la
says
tribu d'Ali
nothing about Ali Kushayb's tribe.
En note de bas de page
In footnote
171,
171,
le bureau du
the
procureur
OTP
s'appuie,
relies
sur les déclarations
on
du
the
témoin
statements
P1021.
of witness P1021
À l'appui de l'information
in
selon
support
laquelle
of the
M.
information that
Abd-Al-Rahman
Mr.
et Ali
Abd-Al-Rahman
Kushayb
and Ali
auraient
Kushayb
servi dans le
had
service médical
served
des
in
armées
the
en
Army
tant que
Medical
Moussaïd.
Service as Moussaïd.
Mais le témoin
But
P1021 ne dit nulle
witness
part cela dans son témoignage.
P1021 nowhere
La
says
référence
in
est
his
erronée.
testimony the reference is
L'information
incorrect. The information
fournie
provided
par le
by
témoin
witness
P874 est
P0874
que Ali
is
Kushayb
that Ali
aurait été
Kushayb
dentiste.
was a dentist.
C'est la pièce 70.
That's item 70,
Ce que M.
which
Abd-Al-Rahman,
Mr.
naturellement, n'a jamais été.
Abd-al-Rahman never was.
P874
Also
répète également
repeated
l'information
the
erronée
incorrect
relative
information
à la
relating to
pharmacie
the
vétérinaire.
veterinary pharmacy. Now,
Les témoins
either
P907, P931 et P984
the
ne disent non plus
0907,
nulle part que Ali
0931,
Kushayb
0984
servait
say
dans le service médical des armées.
anywhere
Les
that
références des notes
Ali
de bas de page
Kushayb
171,
served the armed medical
encore
forces. The
erronées.
references footnote 171 of the
Les
OTP was
témoins
wrong again.
P931
Witness
et P984
P0931 and
mentionnent tous les deux
0984 also both
l'information
mention
erronée
the
relative
incorrect
à la pharmacie
information
vétérinaire.
relating to the veterinary pharmacy.
La Chambre ne peut
The
pas non
chamber
plus se
cannot
fier à
rely
leur
on their
témoignage.
evidence either.
Et la
The
défense renvoie
defense
finalement
refers
à ses
to its
soumissions sur l'absence
submissions
de
concerning the
crédibilité
lack of
des
credibility
trois derniers
of
témoins,
the three last witnesses,
P643, P878
P0643,
et P883.
0878.
L'information
The
relative au
information
service
relating to
de M. Abd-Al-Rahman ou d'Ali Kushayb
Abd-al-Rahman or
au
Ali
Soudan
Kushayb
du Sud
service in southern Sudan
constitue
is
la
the
conséquence logique
logical consequence
de
of
l'information
the
précédente
previous
relative à
information
son service
relating
dans les
to its
forces armées.
service in the armed forces.
La génération de M. Abd-Al-Rahman
What Mr. Abd-al-Rahman's
et celle
generation
10 ou
and
20 ans plus jeune de
Ali
Ali Kushayb
Kushayb's generation, 10 to
ont en
20
commun
years younger,
d'avoir
have in
exercé
common
l'essentiel
is
de leur
that they
service
did
militaire
most of
au
their
Soudan du
military
Sud,
service in
qui
southern
constituait
Sudan,
la principale
which was the
zone
main
de conflit
conflict
dans
zone
lequel
in
le Soudan
which
était
Sudan
engagé.
was engaged.
Cette information
this
encore ne peut servir de
information
preuve
cannot serve
concluante
as
que
conclusive
l'identité entre les
proof
deux
of
personnes.
identity between the two individuals.
Le seul
The
témoin
only witness,
P883 sur lequel
P0883, on
le bureau
whom
du
the
procureur
OTP
s'appuie
relies
en note de
in
bas de page
footnote
172
172
à l'égard d'Ali
with regard
Kouchaïb
to Ali Kouchaïb
parle d'ailleurs
speaks
d'une expérience de
of
combat et de
combat
commandement
and command
au Soudan du Sud,
experience in southern Sudan,
ce qui est
which is
incompatible
incompatible
avec les
with
fonctions
the
attachées au
duties
service
attached
médical de
to the
l'armée,
Army Medical
ainsi qu'en ont
Service, as
attesté
attested
les témoins
to by witness
P643, c'est la pièce
P643,
numéro 56,
item 56,
P883, c'est la pièce
883,
63,
item
D07,
63, and
pièce 85,
D007, item
D16,
85, D016,
et
item
80.
79 and
Le
80.
témoin P883, vous l'aurez
Witness
noté, donc se contredit à nouveau
0883
sur ce
therefore
point.
contradicted
Parle
contradicted
en même
himself
temps
on
d'une
this point.
expérience de
He
commandement
talks
et de
about
combat,
combat and
tout en
command
disant que
experience while
Ali
saying
Kouchaïb
that
était dans
Ali
le service
Kouchaïb was in the medical service, which is just not
contrairement à ce que le bureau
holding
du
ground.
procureur prétend
Contrary to
en note
what
de
the
bas de page
OTP
175,
claims in footnote 175,
l'information selon
the
laquelle M.
information
Abd-Al-Rahman
according to
aurait
which
habité dans
Mr.
le quartier
Abd-Al-Rahman
ouest
lived
de Garcilla
in
en
the West
2003,
District of
2004
Garcilla in 2003,
ne fait pas partie des faits admis
in
avec la défense.
2003,
Nous ne parlons
2004 is not
que de
part of the facts
Garcilla,
admitted by
certainement
the
pas
defense.
du
We talked of
quartier ouest.
Garcilla, but not the Western
Le
District.
témoin D32,
Witness
lui non plus, n'a jamais
032
mentionné
never
le quartier
mentioned
ouest.
the
Il ne parle
Western
que de Garcilla.
District. He only speaks about
Les deux
Garcilla.
seules
The
références du
only
bureau du
two
procureur
references
sur
from
ce
the
point
OTP on
concernant
this
M.
point
Abd-Al-Rahman
concerning
sont
Mr.
donc erronées.
Abd-Al-Rahman are therefore
Le
incorrect.
témoin
Witness
P643 ne mentionne
643,
pas lui non
P643
plus
does
la
not
zone dans
mention the
laquelle vivait
area in which Mr.
M. Abd-Al-Rahman
Abd-Al-Rahman
ou Ali
or
Kouchaïb.
Ali Kouchaïb resided in Garcilla.
La référence
The
du bureau du
OTP's
procureur
reference is
est encore
again
erronée.
incorrect.
La
The
défense renvoie à ses
refers to its
soumissions
submissions
sur l'absence de
regarding the
crédibilité
lack of
des
credibility
témoins
of
P643
witnesses
et P905
P643 and
et renvoie au
P905
paragraphe
and refer to the
698 de
submissions
son
made
mémoire
in paragraph
en relation
698
avec
of
le
its
témoin
brief in
P11.
relation to witness P011.
J'en viens au bâton
Non.
ou à la hache, le fameux
The
Farah.
information relating
Cet
to the
élément est
stick
dénué de
or
la moindre
axe called a
signification.
Farrar is devoid of
Ce
any
point est
meaning
adressé
whatsoever. This point
aux
is
paragraphes
addressed in
732
paragraphs
et
732 and 733
mémoire de la
of the
défense,
defense
les témoins P129,
brief, witness
pièce numéro 65,
P129,
et
item 65, and
P883,
P0883,
pièces 61 et
items
109,
61 and
ont
109,
indiqué qu'il
indicated
s'agissait d'un
that this
accessoire
was
d'usage
an
commun
accessory
au Soudan.
commonly used in Sudan.
Aucun des témoins
None of the
visés par le bureau du
witnesses
procureur
referred
en
to
note de
by
bas de
the
page
OTP in
177
footnote
ne
177
se rapportent à
relate
M.
to Mr.
Abd-Al-Rahman.
Abd-Al-Rahman.
Tous
They're
ne font
all
que parler
linked
d'Ali
to
Kouchaïb.
Ali Kouchaïb.
L'information
Now,
relative à la maison de
The
Niala,
information
au
relating
contraire,
to the
elle
house in
ne
Niala, on the
concerne
contrary,
que M.
concerns
Abd-Al-Rahman
only
et
Mr.
jamais
Abd-Al-Rahman
Ali Kouchaïb.
and not Ali Kouchaïb.
Les autres
The
témoins
other
qui lient
witnesses who
cette maison de
linked
Niala à Ali
this
Kouchaïb ne sont pas
house
crédibles.
to Ali Kouchaïb were not
Le témoin
credible.
P874
Witness
parle d'un cabinet dentaire,
P874 talks about
pièce
a
70.
dental hospital, item
Euh,
70.
Et
And
la défense a
the defense
justifié les raisons pour
explained
lesquelles
why
il
he
n'est pas
was not
crédible.
credible.
Les raisons pour lesquelles le
The
témoin
reasons why
P769, qui ne connaissait même
P0769,
pas
who did not
M.
even know
Abd-Al-Rahman,
Mr.
n'est pas
Abd-Al-Rahman, is
crédible,
not
sont
credible,
également dans le mémoire
are
de la
set, and
défense.
all this is set out in the defense brief.
Quant au témoin
As with regard
P921,
to
sur lequel le bureau du procureur s'appuie,
21 on which the
en note
OTP
de bas de
relies
page
on footnote
178,
178,
il ne mentionne pas cette information.
makes no mention of this
référence est
information.
manifestement
The
erronée.
reference is clearly incorrect.
Enfin, le bureau du procureur
Finally,
se
the
réfère
OTP
au
refers
paragraphe
in paragraph
57 de son
57
mémoire à
of
un
its
poème
brief to a poem
enregistré sur l'un des
recorded on
téléphones
one of the
en
telephones
possession de M.
in
Abd-Al-Rahman au
Mr.
moment de sa
Abd-Al-Rahman's
reddition.
possession at the
En
time
anglais,
of his
c'est la
surrender.
pièce 154.
It's item
Ainsi que l'indique le bureau du procureur, il
53154.
aurait été
As indicated
enregistré
by the
en
OTP,
mai
it was
2010,
recorded in May
soit
2010,
à une époque
at a
où le lien
time when the
entre M.
link
Abd-Al-Rahman
between Mr.
et Ali
Abd-Al-Rahman and Ali
Kouchaïb
Kouchaïb
était déjà
had
dans le domaine
already
public
been publicly
grâce à l'action du bureau du
alleged
procureur
by the OTP and reported in the media.
3 ans.
But
Ni
for
l'auteur
more
du
than 3
poème,
years, neither the
ni
author
la
of the
personne dont
poem
la voix est
nor the
enregistrée
person whose voice
ne
is
sont
recorded
identifiés.
have been identified.
L'enregistrement
The
de ce
recording
poème
of this
s'analyse
poem
dans le meilleur des cas
can best
comme
be
la
analyzed
déclaration d'une personne
as the
tierce
statement of a third
non
party
identifiée
who was not
et qui n'a pas pu
identified
être
and who could
interrogée
not be
comme témoin
questioned
pour
as a
authentifier
witness
et
to
expliquer
authenticate
son
and
contenu.
explain its
Ce
content.
poème
This
revêt donc
poem
aucune valeur
has
probante.
absolutely no
Il doit
probative
être
value
écarté
and
en
must be
vertu
set
de
aside
l'article
under
69,
Article
paragraphe
69, paragraph 4 of the statute.
J'en ai fini avec les
I
correspondances
finished with the
biographiques.
biographical
Aucune
correspondence.
ne permet
None
donc
of
raisonnablement
this
d'établir
can
un lien
reasonably be used to
avec-
establish
entre
a
M.
link
Abd-Al-Rahman et
between
Ali
Mr.
Kushayb.
Abd-Al-Rahman and Ali Kushayb.
Well, that, Mr. Lightshade, if you finish that topic, then that's probably an appropriate time to break.
I would not have proposed better.
Right. All right, we'll break.
Maybe, if the time is not counted for that. I may answer your question regarding the statement of Mr. Abd-Al-Rahman.
Yes, that'd be helpful.
I thought about, I tried to do better than yesterday evening. What I can say more is that Mr. Abd-Al-Rahman has been warned that if he takes the floor, he is waiving his right under Article 67(1)(g. And, of course, what he may say may be used against him. I don't know if that answers your question.
But it doesn't. But I think it's one of the few aspects of trial procedure where there still is a divide between those who come from the same system as Mr. Edwards and those who come from the system that Judge Alipini comes from, and yourself. And as far as what troubled me yesterday, because it is the first time that I've come across this particular aspect, because it didn't exist in ICTY by and large, is how we were supposed to deal with it. But it seems to me, when I reflected overnight, that the best way you can look at it is if it's not evidence, it's argument. And as you say, you've warned him that he's waived his right.
That has been done for sure.
Yeah.
And I defer to your legal authority for the aspect that you just mentioned.
Well, I mean, that's the best way I can see of dealing with it. It's part of the final address, if you like.
There will be no challenge against
Right.
that construction.
Yeah. All right. Thank you very much, and we'll adjourn until 11:35.
All rise. Veuillez vous lever.